Hi everyone, good afternoon. Welcome to the Law School. I'm Fionnuala Nialain. I'm the Faculty Director of the Human Rights Centre, and it's really great to see so many of our alums and our students and just members of our broader law school community here with us this afternoon. I know for many of you, you're back for your spring alumni weekend, and it's just a really important week for our community to reconnect, to get back to the law school, to see old friends, and to hang out in the sunny Twin Cities, because it's been a great winter. So nice that it's sort of mapped through to this week. The event we're going to jump into is part of Spring Alumni Weekend, and we at the Human Rights Centre, Amanda Lyons, who's the Executive Director, and I and Abby and the staff of the Centre, were really pleased to join the law school this week, partly because we have a really close relationship with our alums, and we always relish the chance when many of you are back in town, or you're in town anyway, but you want to come closer to us and come back to the law school. We really relish the opportunity to have you reconnect with us, to reconnect with the Human Rights Centre, and to reconnect with the work. For some of you, this was probably some of the most meaningful places, I hope, and work that you did while you were at the law school. And it's just a really great opportunity for you to see what current students and faculty are doing. Our focus this afternoon on this session, CLE session, is on gender and women's rights. And these issues have really been a long-standing priority for the Human Rights Centre. They predate Amanda and I, and my predecessor, David Weisbrod, had a long-standing and deep commitment to these issues. But for us, it remains critically important that we mainstream and prioritize and elevate women's rights and women's equality in a time when we see exceptional global backlash and, in fact, also significant national backlash to the most fundamental of rights, including women's autonomy. The Centre's work in this area really focuses on supporting researchers, faculty, and of course our students and partners that we have here in the Twin Cities and the state, but also partners in many parts of the world. And so this afternoon is really a chance for you to step into the world of work that we are doing around issues of gender and human rights, and learn a lot about that. I think what's really interesting about this afternoon is you're going to meet and engage with 3 substantial projects that have been running for a large part of this year. And it's really a chance to share with you not just what the broader community is doing, but also what are the takeaways from these particular projects. And in particular, a fundamental thread of the Human Rights Centre's work has been to ensure that we advance the protection of human rights law and human rights institutions in the work that we do. And so partly, I think what you'll see, a thread that you will see across all of the work that you will see presented this afternoon, is the way in which human rights institutions, human rights norms and standards can be used to diagnose, to address, but also ultimately to provide remedy and recompense to those who experience systemic human rights violations, both experienced by women as well as by LGBTQI and gender diverse persons. So I'm going to start by just doing a brief introduction to the 3 projects and those who are here, and then we're going to go straight into the projects themselves. We have 3 specific projects that are going to come to you this afternoon. The first is one that focuses on Bolivia. It's led by Professor Sarah Hoffman, who's sitting right down here in the front row, who is an associate professor at the Nursing School of Nursing here at the University of Minnesota. And her research over an extended period of time, including not just her doctoral work here in Minnesota, but also her work at Johns Hopkins in her time before she came to Minnesota, has been focused on refugee health, on issues of the intergenerational effects of trauma and torture torture. And Professor Hoffman's project is focused on gender-based violence and the barriers to post-assault care in Bolivia. And she's joined by a number of students who've been working with her closely this year, Alex Meisler, Michaela Smith, and Vanessa Voller. And I think one of the really neat things about this project is that it demonstrates the commitment and the work of the Human Rights Center with other parts of our greater university, and the interdisciplinary work that we think enriches all of the human rights work that we do here at the law school. The second project we're going to focus on is a project led by Megan Mannion, who's a law school alum, a 2016 alum of the law school, who came back to the Human Rights Center in 2020 as the senior legal advisor to the mandate of the Special Rapporteur on Counterterrorism and Human Rights when I held that role, but had spent many years previously working really on the front lines of women's rights advocacy, both in UN headquarters in New York and in Afghanistan with UN Women. And Megan's been working again with three wonderful students, Madeline Kim, Kaiten Lippard-Masad, and Sierra Paulson, who are also here in the front row. So they're going to be the second project up. And then our third project is, again, a really important project that brings together a really local focus on issues related to the visibility of children who are placed in prison with a mother. That's essentially children who are the children of incarcerated caregivers. And that project is a really lovely partnership between the Human Rights Center and Julie Mantonich with one of our great students again, Alexa Johnson Gomez. And again, we're really pleased to partner with Julie, who has been working on issues of criminal justice and criminal offense for particularly marginalized clients for a long time, but has also been a pro bono lawyer working with the Advocates for Human Rights and serves on a number of boards, too many to name, but including the Minnesota Association for Criminal Defense Lawyers. So we have an exceptional group of faculty and practitioners here, and we have an extraordinary group of students. And so it's my great pleasure to turn over to the first, and Abby is gonna have us, and I'm gonna invite Sarah, Alex, Michaela, and Vanessa to come up and start their presentation. And I just want to note for those in the audience that this presentation, it should be obvious to say, includes a discussion of sexual violence. So just to be aware that the content of the presentation is one that might be challenging for some in the audience, but we hope that you will all stay with us. All right, so I'm going to hand over to Abby.
All right, good afternoon, everyone. My name is Sarah Hoffman. Thank you so much for being here and for the invitation to come and talk with you all today. I'm just going to introduce the project briefly, and then we're going to move into progress to date. So as Fionnuala mentioned, we are not going to be talking about details of sexual violence or specifics of cases, but we do talk about prevalence of sexual violence in Bolivia. We start with a case that's grounded in sexual and reproductive health, but where there are elements of sexual violence at play. And then we are going to present some just sort of high-level findings that we've had thus far in our pilot, but they are a step back from detailed discussion of sexual violence. We also wanted to acknowledge our funding. The Center for Global Health and Social Responsibility seed grant and global engagement grant mechanisms are funding the research project in Bolivia, and we're very grateful to the Human Rights Center who's supported the student involvement that we have. And then we want to make sure to mention our Bolivia-based partner. We are working with an organization called ETA Projects that has a long-standing history in the community where our work is focused currently. These are the names of our primary partners. Unfortunately, they can't be here today, but we've done our best to integrate their perspectives and their voices in the presentation. This work would not have been possible without this community-partnered approach and such a rich organization. And so with that, I'll turn it over to Vanessa.
Okay, thank you so much. All right, I'm going to spend just a few minutes walking us through the overview of the project, and first by grounding us in the initial case that was the impetus for our research. But first, I'd like to start with a quote from Dino, who is the Director of Operations at ETA Projects, and this is him speaking to the impact of our work. And he states that this research will allow us to better understand the challenges and issues faced by young women and girls when they suffer from sexual abuse or assault. The outcomes of this will impact future interventions addressing this problem in a more integral and thoughtful way, involving the health and educational sector and families from the communities. ETA Projects, as Sarah mentioned, has been absolutely instrumental in our work, and they are the people on the ground year-round working on various initiatives, this being one of the initiatives that they're focusing on this year. And they're also partnering very closely with local government entities as well to ensure that the results from our research make it out to the elected officials who ultimately are making policy decisions at the local level. So I wanted to bring you all back. This is a classroom that I had an opportunity to visit in 2019. In 2019, I was there as part of my doctoral fieldwork, and I had an opportunity to sit in and observe a training for 25 adolescent girls about gender-based violence and about sexual and reproductive health. At this training, I was told that this 2-hour workshop would help curb, if not eliminate, gender-based violence in the region. And as a researcher, I was pretty surprised because I was looking around at a classroom of about 25 adolescent girls, and it really made me wonder, like, what agency do these young girls have in a setting where there is rampant abuse and violence, very limited legal, medical resources, and other huge sociostructural barriers impacting their health? And that's what we're going to be talking about today. So this case begins with Isabella. This is a pseudonym for a young person that I met in that classroom in 2019. Fast forward a few years later, I had an opportunity to speak to a physician who had treated her actually, because she had returned to the NGO that was running the educational initiative, and she shared that she had, the translation would be some bumps, and some bumps meaning that she had some injuries that the doctor then found upon physical exam that were consistent with chronic abuse and sexual violence. So what this case really showed to us is, even though this educational training was supposed to curb gender-based violence in the region, this young person who had participated, they still suffered from abuse. And so this was really the start of this project, was looking into the limitations of this educational initiative and to really document and analyze what are the human rights violations that are occurring in this site. And we're working in Montero, Bolivia, which is about 30 miles north of Santa Cruz. There's about 170,000 people that live in this peri-urban area, and a lot of the communities that we're focusing in are on the outskirts of this town. So what we've found so far is that this education as panacea is kind of the framework that we're working with, which really posits that educational initiatives will end and eliminate gender-based violence and solve the many complex issues that are facing young girls and women in the region. And what we're hoping to do is, again, show that actually the story is much more complex than that, and that there are gross human rights violations that are occurring at the local level that really, although these educational initiatives are important, they're not addressing the real material needs that young people have. So our research aims, we have two primary aims. First is to document the prevalence, the type, the severity, and the frequency of violence occurring in two communities, our two sites that we're looking at. We're hoping for about 200 surveys to be completed over the next 5 months. And then secondly, to describe the perceived impact and challenges to receiving post-assault care in this rural resource variable setting. Our methods are twofold. Our first phase is our community engagement and outreach phase. So this has included training 20 community health workers and nurses to assist in our data collection for our surveys that we're conducting in clinics in the region. And then secondly, doing focus group discussions as well as in-depth interviews with those that are doing the surveys as well as other clinicians on the ground. And that's the phase that we're in right now, is that data collection period. These are a few photos from our training that occurred in January. What was really special about this training is that it was primarily led by our Bolivian colleagues, Dr. Caterina Sensano, who's a family medicine physician down on the bottom right screen, as well as a local psychologist as well, who assisted in ensuring that trauma-informed care was a huge part of our training and that surveyors would be prepared to do the data collection in a trauma-informed way. Earlier this week, we had a chance to meet with our research team, and we found that our preliminary results suggest that of the 17 surveys that we've completed to date, there were 8 confirmed cases of sexual and physical violence, and others reported experience other forms of psychological violence and verbal abuse. Other themes that emerged in our first set of surveys include a fear of retaliation from family, friends, and other community members with disclosure, lack of resources available to actually do the reporting, to seek that post-assault medical care, as well as legal resources, transportation barriers, and then cost-prohibitive medical care as well. Our next data collection period will be just in a few weeks in early May.
Great, so some of the work that Alex and I have done is integrating a human rights legal framework into this study, both in theory and then examining the reality in Bolivia. So components of the human rights framework for this study include international human rights instruments, regional human rights instruments, and the Bolivian Constitution and law. The Bolivian Constitution includes an incorporation of all the relevant treaties at a higher hierarchical dominance than other Bolivian law, and so all of these instruments kind of dominate over the Constitution and law. And so through this, we were able to identify some obligations for Bolivia. So Bolivia has the obligation to provide comprehensive care. This exists across human rights instruments, especially related to family planning and reproductive care services, and especially related to programs for children. And then Law 348 calls for care for survivors of sexual and gender-based violence. Bolivia has the obligation to prevent sexual violence. This is identified in CEDAW, in the Convention on the Rights of the Child, and in several other instruments. And the Inter-American Convention on the Prevention and Punishment and Eradication of Violence Against Women also requires states to take measures to prevent violence. Bolivia has the obligation to provide comprehensive services for survivors, which include investigative services as well as comprehensive medical, psychological, and other care services. And states who've signed the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women agree to provide services to women affected by violence, such as sexual violence, as well as to their children and witnesses. Bolivia has the obligation to provide a remedy for survivors, which is to say that they're required to establish legal procedures for those who've been affected by sexual and gender-based violence. As well, with reference to our engagement in Montero, especially with young women, Bolivia has a broad obligation to rural women and to youth.
Thank you. So to examine some of the data we have collected so far, 75% of women in marriages or long-term relationships have reported experiencing violence at some point in their relationship. First off, this is from probably the most comprehensive report on violence, gender-based violence in Bolivia, which was conducted in 2016 at a national level. These numbers also begin to inflate the more you focus on rural areas as well, and that's just on reported cases as well. So there's a huge amount of cases that kind of left unseen, in a sense. This number takes into account psychological violence, physical violence, sexual violence, and economic violence. The total number of women, the total percentage of women who have experienced all four during their lifetime is 17.4% as well. The World Bank has also provided a very useful study comparing the international level of intimate partner violence in Bolivia, in which it's an extreme outlier in its region. In Bolivia, 42% of women have experienced at some point of their life intimate partner violence. The regional average is 25%. However, some of their neighbors exhibit relatively similar rates, Peru at 38% and Ecuador at 33%. So to refer to some of the underlying causes for these numbers as well, which Vanessa has provided before, the first one is access to justice. There's a general distrust of authorities. In the first place, there's a huge number of abandonment of cases by way of public defenders. There have been these huge corruption scandals in Bolivia, especially after the case of Ricardo Choque in January of 2022, which provoked mass demonstrations in the streets by feminist organizations, in which judges had continually taken bribes to ignore allegations towards serial rapists and femicides. There's also a general problem in the lack of resources. The Special Force Against Violence, many NGOs have reported on the ground, is not properly funded. Neither are the public defenders who are even willing to help. These lack of resources also is very clearly reflected in the lack of resources in reproductive health care. There are very comprehensive reports that show that are the 44 establishments in Bolivia that are supposed to provide access to abortion for Bolivian women. Most of them do not have either adequate staff training, adequate infrastructure, or adequate medication for women, and according to the guidelines provided by Bolivia's legal framework. And this also reflects in the unkept promises of funding. Bolivia has an ordinance in which states have to guarantee 15% of the income and some taxes towards gender-based violence prevention. And even though some states, like Santa Cruz here, we can see, promise around, this is in Bolivian pesos, provide, I believe it's around 17% of their income, which is above the 15% the law requires. The actual application of that is later way below what it should be. Santa Cruz promised to apply 9 million Bolivianos, ends up applying 1.2. This is tracked by the coordinator of the women in the NGO Gender Observatorio de Género in Bolivia. And finally, there's also a huge issue regarding awareness of gender-based violence law. Though many young women are more aware of gender-based violence law, they are, most women remain unaware of their rights regarding that, especially when we go again to rural areas or regarding women who have not completed high school education. This again is seen reflected in the area of women's healthcare, where a lot of specialists regarding women's reproductive healthcare do not know the proper guidelines in which abortion procedures have to be taken into account, or when the timeline they're supposed to respond in is supposed to be taken into account. And Santa Cruz tends to follow the national guidelines in this sense. They are not necessarily outside the national averages.
So through this data and the framework that we've developed, we can identify discrepancies. Clearly, Bolivia is not meeting its obligations, and discrepancies exist between its legal obligations and what it's doing. We can use that to push for change, and then finally we can use that to improve care and access. So this study is already helping to develop frameworks for care and helping to do some capacity building in the region, and hopefully we'll continue to do so. I went back.
So we just wanted to end going back to our initial case, which was Isabella, and specifically thinking about Isabella and the physician that day that received her at the NGO who is responsible for her care, and really thinking about how at every stage of this care delivery chain, Isabella is facing challenges in getting timely, trauma-informed, culturally responsive care, as well as legal support. So we're hoping that through our study, which will continue throughout the summer and we'll be wrapping up this fall, we'll really document that and show where Bolivia is falling short in meeting the obligations that it's outlined in various national and international human rights instruments. So hopefully showing again where those specific care delivery provisions are falling short. And that's all we have for today. Thank you so much.
Many, many thanks to Professor Hoffman, Alex, Michaela, and Vanessa. And I also just wanted to acknowledge that in the context of the work that they're doing, that both Alex and Michaela are Human Rights Center Fellows and Research Assistants for the summer of 2024. And that support is made possible by the Heinz Research Support Fund, which is housed at the center and has been enormously facilitative of so many of our students getting opportunities they wouldn't otherwise have. So now I'm going to turn to Megan and to Madeline, Sierra, and Caden to come up and bring us their study, which is going to look at reform of discriminatory laws and transitional justice, the case of Nepal. And one important thing, which I know Megan is going to talk about at more length, is this project is the culmination of really through Megan's relationship with UN Women, has been the product of a sustained relationship by the Human Rights Center and the law school with UN Women. And so one of the things that our students get to do that nobody else really gets to do, I think, is because of these long-standing relationships with international organizations, that our students have opportunities to work at the really the highest level and with some of the cutting-edge work that's happening in the UN system. So over to Megan.
Thanks, Fanula. Thanks, Abby, for putting up the presentation. I'll just be very brief. As Fanula said, my name is Megan Mannion, and I'm a senior research fellow at the Human Rights Center. In addition to doing the work with Fanula under her mandate as special rapporteur, I've also had the privilege to work with students on some of these important issues around women's human rights and gender equality more broadly. Two academic years ago, we started this project with UN Women, and it's an externship opportunity for students to really gain firsthand experience working with an international organization, but also not just to work with that international organization, but to see how they conduct their work working with civil society, with broader partners in the UN system, and their country offices. So for this year, I've been really excited for the students to dig into a specific case study, and they'll talk a bit more about that, focused on Nepal and the role of legal reform as it relates to transitional justice and the success or challenges that come along with transitional justice on gender equality issues, but more broadly on sexual orientation and gender identity issues during conflict. So with that, I'll hand over to the researchers and let them take over. Thanks.
So we first want to kind of place our case study into a bit of context. So our case study on Nepal is part of a broader report being done by UN Women. This report is examining the role that reform of laws that discriminate against women, girls, and LGBTIQ plus individuals plays in the transitional justice process across different countries. One of the main aspects of this is examining how legislative reform can serve as a mechanism for achieving transitional justice goals, such as the non-repetition of gendered violence and ensuring accountability for perpetrators. So the case study that we conducted on Nepal will be included in this report, as well as a case study on the transitional justice process in Colombia. So just to start off, I'm going to give a little bit of background on Nepal, and specifically on the conflict in Nepal. So the root causes of this conflict were based both in the suppression of civil liberty and civil society and on situations of rampant inequality due to entrenched caste and patriarchal systems. Nepal is a small but incredibly diverse country that's home to lots of religions, lots of ethnicities, and due to the monarchy system that was in place prior to the conflict, these different religions and genders and the caste system created a huge trench in inequality in society. So a brief timeline, Nepal was a monarchy starting in about 1786 and was largely unchanged in terms of ruling party and ruling family. In the late 1980s, there was a democratic revolution in Nepal, and this led to the restoration of a multi-party system and sort of the emerging of democracy. One of the parties that emerged from this movement, the Communist Party of Nepal Maoist, who I'll be referring to as the Maoists, began to call for an armed revolution, and in 1996, they submitted a list of 40 demands to the government. When the government did not give in to these demands, they started an armed conflict. This conflict lasted a decade. It began as a low-level conflict that was mostly on the fringe of the country, but it escalated into a brutal internal armed conflict that affected the entire country. As part of the response to this escalating conflict, the king at the time, King Gyanendra, abolished the government in 2005 and declared himself absolute monarch. This crackdown brought mass protests and eventually forced his resignation in 2006. Shortly thereafter, both the Maoist and the government forces agreed to a ceasefire and negotiated the Comprehensive Peace Accord, which was signed in 2006. Throughout the conflict, there were massive violations on both sides, including the right to life. Over 13,000 people died. Forced disappearance, there were over 3,000 disappearances, many of which are still unsolved to this day. And there was rampant conflict-related sexual violence on both sides. Additionally, as a result of the breakdown of law and order and impunity for non-combatants committing sexual violence, there was an increase in sexual violence amongst non-combatants as well. Finally, there was forced displacement. Hundreds of thousands of Nepali were displaced by the violence. This conflict has had a continued impacts on everybody in Nepal, but particularly on women and people of diverse sexual orientation, gender identity or expression, and sex characteristics. These go beyond the initial psychological and physical impacts. For example, there are lots of economic impacts expressly experienced by women. Survivors of CRSV, predominantly women, are excluded from the interim relief program, which prevents them from gaining access to the same financial compensation as men who were victims in the conflict. Additionally, due to the entrenched patriarchal system, widows experience economic problems beyond mental and physical health impacts. Despite work by the democratic Nepali government to remove gender discriminated policies, there is still a huge issue of women's having access to their husband's property after their death. Widows who do have to enter the workforce are also more likely to suffer abuse and less likely to be covered by legal workplace protections. Also socially, many women still face violence and shame, both about widowhood and about sexual violence experienced because of the conflict. There was no established mechanism as part of the comprehensive peace accords to address sexual violence in the conflict, and there's a lack of resources generally, as well as a lack of doctors and therapists trained on sexual violence. It's important to note that these impacts are compounded on those with intersexual identities. In particular, LGBTQI+ individuals, especially those that interact with the patriarchal structures, such as lesbians, bisexual women, and the transgender community, experience an increase in violence during the conflict. And to end on kind of one positive note coming out of the conflict was the opening of civic space, which we'll talk about more. But before the conflict began, there was no civil space, there was no space for NGOs and advocacy groups to operate formally. But by 2000, over 30,000 NGOs were registered in Nepal, many of which are relating to LGBTQI+ rights and gender issues, and many who are led by women rights defenders.
So our transitional justice framework sort of begins after the beginning of the formal peace process, which began in 2006 with the signing of the peace agreement. And so the transitional justice framework is composed of three primary systems. And so we have the formal Truth and Reconciliation committees, which were formed under the Truth and Reconciliation Commission Act of 2014, which I will be referring to as the TRC Act because it is a bit of a mouthful. We also have robust involvement by the Nepali Supreme Court and then the national action plans under the Women, Peace, and Security agenda. So the Truth and Reconciliation Commissions were formed in 2014, which you'll notice that there's a 7-year gap between the peace agreement and the formation of the committees. So this was because of a prolonged, protracted negotiation process, primarily between civil society and the government, primarily over the issue of amnesty and what would be defined as a serious human rights violation. And so there was significant engagement with civil society throughout this process, including notably 19 rounds of consultation, which occurred in 2009. However, unfortunately, the bill on which these consultations occurred is not the bill that was eventually passed into law in 2014, in part due to the dissolution of parliament for elections. But there was eventually, the bill that was passed into law in 2014 is actually a bill that was authored by the three primary political powers at the time, which was then passed into law. So the two commissions which were formed under the TRC Act are the Commission on the Investigation of Enforced Disappeared Persons and the Truth and Reconciliation Commission. The two commissions collectively have received 63,000 allegations of serious human rights violations and unfortunately have not solved a single case or have not come to a full resolution on any of these cases. However, actually many civil society groups actually point to this as a positive sign because it speaks to the degree of engagement that you see among survivors and conflict victims. especially because many of the Peace Commission offices are actually staffed by men, which means that if you're a woman or a gender-expansive individual who's reporting a sexual assault or conflict-related sexual violence, it can be very difficult to do that to a male staff member. However, there are also victims groups which state that they are engaging in, quote, critical engagement with these commissions and that they are utilizing them as mechanisms but are not necessarily fully buying in. However, there have been recent reform efforts of both of these commissions under both May and October amendments, which have been proposed in 2023. Unfortunately, neither reform bill has passed, but the willingness alone to hear these reform bills is a positive sign following the elections of a new parliament in November of 2022. And some of these proposed reforms do seek to make the commissions more transparent and more, quote, victim-centric and gender-friendly, so they are seen as a positive movement. The barriers to actualization that are faced by these commissions are significant. Two of the primary ones are the Citizenship Act, which requires that children of Nepali women who have children be able to prove that the father of their child is also Nepali, or be able to prove that the father of their child is unknown, which leads to some serious issues in terms of the dissemination of property, particularly if you have widows or children of people who were disappeared during the conflict who are now no longer able to inherit their property. But there is new language in these amendments that were proposed in 2023, which would make it easier to transition property from individuals who were forcibly disappeared to their widows or their children. In addition, we have the issue of the reintegration of Maoist ex-combatants, in part because the definition of a complainant is limited to unarmed persons and members of the civilian population, so women or men or gender-expansive individuals who suffered conflict-related sexual violence while they were a combatant are not covered by the Truth and Reconciliation Act. In addition, we also see issues where the reintegration programs and the reforms that are available and the reparations that are available to ex-combatants are gender disparate, so we do see more programs available to male ex-combatants than we do see to female ex-combatants. But again, there is some good language in these proposed amendments from 2023. However, there are still some qualifiers placed on the language of victim, which means that there would be individuals who still would not be covered. Moving to the involvement of the Nepali Supreme Court, they actually have been one of the most active and most engaged members of the transitional justice process, and there's two very notable examples from earlier on in the process that we have here, and one of them is there was actually a ruling that the Supreme Court issued on the proposed TRC Act in 2015, right after it was passed into law, and this lawsuit was brought by civil society organizations who were displeased with the fact that the bill on which they had consulted was not the bill which was passed into law, and the Supreme Court did actually issue a very detailed and effective decision in that it would work to bring the TRC Act into better alignment with international norms on transitional justice. However, it has not been followed thus far. In addition, we also have a significant line of conflict-era abduction and torture cases, which the Supreme Court has issued, which actually did provide an avenue for justice for individuals who had suffered under the conflict as well, prior to the establishment of the formal commissions. Turning finally to the national action plans, which are implemented under the implementation of resolutions 1325 and 1820 in the broader UN Women, Peace and Security agenda. The first national action plan in Nepal was adopted in 2011, which was very widely hailed as it was very early adoption for South Asia. It's one of the first in the region. However, there was fairly extensive criticism of the initial national action plan for a lack of inclusion of LGBTQI individuals as well as conflict-related sexual and violence. However, in the negotiations of the second national action plan, the government actually did work to address some of these concerns and did consult with both women's groups and LGBTQI advocacy groups. In particular, they invited the Federation of Sexual and Gender Minorities in Nepal to speak to the government on the drafting of the plan. The second national action plan was passed into law in 2022, but will expire in September of 2025. But it is being pointed to as a sign of progress in that it does focus explicitly on conflict-related sexual violence, and in particular does have significant efforts on confidential data collection, which people are looking forward to seeing, help actualize other transitional justice efforts. So ultimately, although it's not formally named as part of the transitional justice process, the national action plans do provide an important avenue of redress for victims that accomplish very similar aims as the formal transitional justice framework.
So Madeline spoke a little bit to the barriers to implementation in terms of the transitional justice process. And I'm going to speak a bit about the ongoing human rights violations, which are still very much prevalent and pervasive in Nepal. So despite multiple iterations of these transitional justice processes and attempts to generate further reforms, many of the human rights violations which both caused and resulted from the conflict are still very prevalent. And many of these violations stand in stark contrast to reported progress by the Nepali government and others. So just to mention a few of these violations, there's a very high prevalence of child marriage in Nepal. As of recent data, it has the third highest rate of child marriage in Asia, and among women 18 to 49 years old, over a third of these women reported being forced to marry before the age of 18. As Madeline alluded to, there's also ongoing discrimination caused by the Citizenship Act. So children of women who are married to non-Nepali men, unmarried women, rape survivors, and many others face issues accessing services. Their children are not able to be full citizens of Nepal, and therefore their right to nationality is violated, and with that comes a number of social and economic challenges in terms of accessing services. In addition, there's rampant violations of the right to health care. Abortion is still criminalized in Nepal, despite advocacy efforts to change that. Coercive medical interventions, we found, are also unfortunately common for LGBTQI+ children, notably intersex children, sometimes amounting to ill treatment under international law. And really, on the whole, what we've seen is a lot of these existing human rights violations stem not from a lack of legal reform, but from implementation challenges and entrenched social and cultural practices. Despite many of these harmful practices being criminalized formally, they still exist. It's still ingrained in kind of the patriarchal nature of Nepali society. And the transitional justice framework that we've discussed today has not really been implemented in a way that adequately serves justice to marginalized groups, especially women, children, people of diverse sexual and gender orientations, and many others. There's too many to name. So there's still significant challenges, but kind of on the flip side, turning to a bit more of a positive light here, we found that in the wake of the passage of transitional justice mechanisms, a number of positive legal reforms have taken root. Multiple pieces of legislation have sought to address a wide spectrum of harmful practices and codify provision of social and economic assistance to poor and marginalized groups. So notably, the Penal Code passed in 2017 and the 2018 Crime Victims Act address these harms that disproportionately impact women and LGBTIQ+ persons. There's also been an amendment to the Citizenship Act, which formalizes a third gender expression. So people of third gender can, they have the formalized right to nationality, and they have the option to obtain their identity documents with expression of their preferred gender. Also, the statute of limitations for reporting rape has been extended multiple times as the result of advocacy efforts. Advocates are still working to extend that further. It's now 2 years. Previously, a few years ago, it was only 35 days. So you can see the change in progress that's been made there. And finally, in a big win for LGBTQI+ rights, the Supreme Court of Nepal ruled to require the government to formally register same-sex marriages as of 2023. So that's been a big step that we've noted as well. So to bring us to the conclusions of our case study, there's 3 main things that we noted. The first being the importance of an open and robust civic space. Despite implementation challenges, ongoing human rights violations, we've seen that without the opening of civic space, which was which began when the change of government and entrance of democracy began, and these transitional justice mechanisms began to be implemented. Without that opening of civic space, a lot of these changes would have been impossible or much slower moving. So that's a notable aspect that we found throughout our work.
Our second conclusion is that, as you saw from our presentation, unfortunately, the existence of transitional mechanisms alone are not sufficient to guarantee the rights or to actualize the rights that are guaranteed. In particular, we feel that addressing the complex and multifaceted harms that both existed prior to the conflict, stemmed from the conflict, and continue to occur after the conflict do require that increased engagement of civic space, and we do see the continued engagement of civil society as a potential solution to actualizing the transitional justice framework that does exist.
And finally, through our case study and our research, we found it's really important to have an approach to gender-sensitive legal reform that's rooted in a broad spectrum of rights. So this includes the fulfillment of economic, social, and cultural rights, and not just civil and political rights. This is particularly important in a country like Nepal, where the conflict stemmed from a lot of tension having to do with the lack of access to economic, social, and cultural rights. And so this is an important thing to note moving forward in other areas that are working on gender-sensitive transitional justice. Thanks.
Yeah, thank you.
And just to say how important, I think those of you who've been watching the changes in legal education and the ABA standards and rules on a greater emphasis on experiential learning, the extent to which the law school continues to extend those experiential opportunities. The Human Rights Centre is really committed to doing that kind of existential possibilities for our students, and these kinds of field placements are really extraordinarily important to that. There are not as many of them as we would like to have. It takes a lot to make a field placement happen, including these kind of relationships that Megan has brought with her to the centre as our senior legal fellow, but it speaks to the kinds of things that we would like more of our students to be able to do. So our final presentation, I'm going to invite Julie and I'm going to invite Julie and Alexa to come up, and they are going to present to us the project that they've been working on elevating the visibility of children placed in prison with a mother. And I just want to say that the Children of Incarcerated Caretakers is a long-standing partner of the Human Rights Program here at the university at large, at CLA, and when particularly a long-standing and close relationship with Barb Fry. And also just to acknowledge that Alexa is a Human Rights Centre Fellow and is also working with the Children of Incarcerated Caretakers as part of our field placement program. So over to you both, and looking forward to it.
Thank you so much. I'm just going to say a few words about Children of Incarcerated Caregivers, or CAC, as we call ourselves, and then Alexa will talk about the work that she's been doing with us over the past year. CIC was started about 8 years ago by a number of attorneys, human rights activists, and community members who were concerned about the impact of parental incarceration on young children. And we all came to be concerned about this issue in different ways. I think it's just miraculous to me that the person who I was with when I became most interested in this is here today. I didn't know that Tom Kelly, an alum, I think from the class of 67, 69, criminal defense attorney who I worked with for the first 10 years of my career in criminal defense, is here. And he and I had a case in federal court involving a dad who was the primary caregiver for his 3-year-old son. He was really the only caregiver for this young boy. And that dad was facing a draconian sentence in a first-time drug offense in which he had a very minor role. And we ended up losing that case, heartbreakingly, and the dad went to serve a 12-year sentence in federal court, and I learned later that the son was basically lost in the system. that case has stayed with me, and it reminds me to think about fathers as primary caregivers, but mostly what we're talking about are mothers when we're focusing on the impact of parental incarceration, because in more cases than not, when a father is incarcerated, the mother raises the child, but when the mother is incarcerated, it's often not the father. It's another person or foster parent or friend or relative that's raising the child. Particularly in the case of prison nurseries, which Alexa's going to talk about. Prison nurseries, also known as mother-baby units, or just situations where children are living in a prison with a parent. Most often that those cases involve mothers and not fathers. So I just want to talk a little bit briefly about our process. The way that we became interested in this issue of prison nurseries was through student research and this longstanding collaboration with the University of Minnesota. Barb Fry, the former director of the Human Rights Program here, is one of our founding board members, and she's a co-director of the Prison Nursery Project. And our model has been, since our inception, to work with student researchers, student research fellows, who identify gaps and in which we can hopefully help fill in. And our early researchers 8 years ago identified this issue of prison nurseries, which is understudied, not receiving nearly enough attention in the US or globally. And we set out to try to learn more, to share the knowledge that we were gaining, and to eventually do advocacy in the field. Through those relationships that the students and through their research, reporting, and interviews have created, we're establishing a global network of NGOs and researchers who work on issues related to prison nurseries, and that involves collaborating with one another, talking about best practices, common problems, and advocating for the best interests of children. And that Alexa has been very involved and extremely helpful with us in focusing on international laws and particularly issues involving gender. And she will be presenting her work at a symposium that we're hosting in combination with Columbia Law School's Journal of Gender and Law, or I think Law and Gender, in November. And she's going to tell you a little bit about the work that she's been doing.
Thanks, Julie. So first, I just want to start with some necessary context as we talk about prison nurseries. There's so many overlapping issues, and I kind of frame it as motherhood, incarceration, and children's rights. So first of all, the general rise in incarceration has also led to more women in prisons, and when women go to prison, that means more mothers go to prison. This has a hugely negative impact on children. The separation of a mother and child, regardless of age, is going to negatively impact that individual for their entire life. And there is a subset of cases where infants or young children will go to prison with their mothers, as Julie mentioned, in prison nurseries or mother-baby units, and that's mostly what we'll be talking about today. So a little more on incarceration of mothers. As I mentioned, incarceration has risen overall, but women outpace men in the growth of incarceration in this modern era by 2 times. In the US alone, some 190,000 women are incarcerated currently, and most of these women are mothers. Roughly 80% of incarcerated women are mothers. A big thematic question that then emerges is, when courts are sentencing these women, should they be taking their motherhood into account? Given the negative impact on children, which we'll talk more about shortly, there's an argument that judges should be considering this and should be thinking about keeping mothers with their children if possible. This relates to sort of sentencing alternatives and diversionary programs. A counter-argument to that would be that it's sort of an unfair advantage for women to have an extra sympathy card, so to speak, but
We know that judges consider many contextual factors, and ties to the community can always be strong mitigators, so it's not any too different than any other factor that's going to be considered during sentencing. But now let's set that aside and kind of consider the parallel issue of the child of an incarcerated mother. Researchers have demonstrated again and again that there are significant negative impacts on children when their parent is incarcerated. That, in a nutshell, as Julie said, is why CIC was founded. And in the short term, effects can include impact on well-being and future outcomes, the changing of home and carers, which subjects the child to a really unstable environment, increased poverty, disrupted education, social isolation and stigma, and changed behaviors as a result of all of these. But it's not just this, it's also in the long term that the individual faces really negative impacts. A person who was a child of an incarcerated caregiver is roughly 6 times more likely than other similarly situated children to enter the criminal justice system. They're less likely to enter into education, training, or employment in their life. They're more likely to have mental health and addiction problems. They're likely to earn less than their counterparts at age 30, and most grim of all is that they're more likely to die before the age of 65 than their peers. So then we come to the question of why prison nurseries? Well, because of the rise in incarcerated mothers, because of the negative effects on children, when we can remove that negative impact whenever possible, that's arguably a good thing. And prison nurseries is one way that that can happen. We can arguably preserve the bond between mother and baby by keeping them together, and that's really crucial to brain development. Scientists have demonstrated that a strong bond and a strong attachment between mother and baby really allows children to grow into happy and resilient adults in their life. On the flip side, mothers can potentially become better parents through a prison nursery program. An ideal prison nursery would offer classes while they are staying within the prison nursery, and perhaps they would also then be deterred from committing crimes in the future by having this tie to the community that has not been severed through incarceration. Some facts about prison nurseries. We know that they are a practice in about 97 countries. That includes 8 states in the US. And roughly the estimate is that about 19,000 children are in prison nurseries, but that is probably a really low estimate. It's probably a lot more than that. It is just kind of impossible to know the actual numbers, and in part that's because this is such an understudied area. The human rights of these babies and young children are virtually ignored, and they're really just an invisible population, and a hugely vulnerable population, obviously. So as a research team, we have considered how we might bring attention to this issue with all of the various legal approaches that we could take. One initial strategy is to apply a human rights framework to this, and specifically, we are focusing on due process. So this is because the exact path of how a child might end up in a prison nursery is hugely murky. We don't know how states initiate these proceedings. It's more likely than not that these some 19,000 children had no formal determination whatsoever. We know of a couple countries, for example, where the rule is that the child simply goes to prison with the mother. There's no determination, there's no stopping it, it just happens. And so importantly, if we want there to be a process, what should such a process look like? And what rights would the child have in that process? What rights would the mother have in that process? These are kind of the questions that we're considering as we do more research. The formalistic standard from human rights law comes from the Convention on the Rights of the Child, specifically Article 3, which touches on the best interests of the child. Essentially, the text says that the best interests of the child shall be a primary consideration in any kind of official legal proceeding or action. This is a very malleable standard. It's very expansive, very broad. It's meant to be that way so that it can fit into many different proceedings like family law or refugee situations, the whole gamut of any thing that a child is at stake in. So in applying a human rights framework, our initial goal right now is norm building. We want to ensure that there actually is a process for these children that involves some kind of formalized best interests determination. Along the way, we're constantly asking ourselves what that procedure actually should look like and what the criteria that a decision maker should be considering are. It's also important here to return to the sort of original framing of this presentation, that it's not just about the child, it's not just about the mother, but it's about both of them. And it's really important to be balancing the human rights of both the child and the mother in any kind of determination that we're doing about prison nurseries. To more specifically get into our strategy to address this issue, and Julie mentioned a few of these things, we are aiming to publish scholarship, to co-host a symposium this fall, and to launch a global network of NGOs. By undertaking these three aims, we really hope to create a consensus on the minimally acceptable process, a process that can be applied in any state regardless of resources. This publication goal is an article that Julie and I are co-authoring. It's very specifically about best interests of the child and having a formal determination as to whether the child will go to the prison nursery or not. And then the symposium, as Julie mentioned, is going to be at Columbia Law. We're very excited about that. And then this network, we're really hoping to sort of build a coalition of NGOs who are involved in this issue area, and get more conversation going and really connect different organizations worldwide. To give sort of a flyover view of the article that Julie and I have been writing, we're focusing on interpretation of Convention on the Rights of the Child to assert what the convention says about how this determination must be structured. This is based on Article 3, but also other guidance that the Committee on the Rights of the Child has promulgated. General comments, a day on children of incarcerated parents, that was in 2011, and then a few instances of pertinent concluding observations. We're also going to be referencing different persuasive authority, such as legislative history, refugee guidelines from the UNHCR, and some instances of judicial interpretation. And then we're also going to be acknowledging that this concept of best interests is very tightly tied to other rights of the child and the mother, as well as international rules on detention conditions, that's a really important part of the balancing process to be considering, what are the conditions within a prison that a child is hypothetically going to go reside in. Lastly, we're hoping to sort of summarize all of these recommendations into a condensed policy sheet, so that one day states could perhaps refer to this and be able to structure their procedure based on all of this international law. So if you are interested in learning more about the work done by CIC or the Prison Nursery Project, this is our website, cicmn.org, and then we also have a podcast which is hosted by Barb Fry. If you want to scan the QR code, it'll take you to the podcast page. Thank you so much.
Stay, and we'll invite all of the panelists, if you're okay, Professor Hoffman, Alex, Michaela, Vanessa, Megan, and Madeline, Caton, and Sierra to come up. And we have about just over 10 minutes of Q&A. So, and we have a roving mic. Abby has the roving mic, and Amanda has the roving mic. So, over to you all. And I think we should give them all one big round of applause. How much great work. I see Charlie. It's yours.
Trust me, I could take
one of our other incredible supporters of the Human Rights Center. So, Charlie.
Well, how can you not support when you see this work? First of all, so impressive. And to see the gender imbalance, I love it. Quite honestly, as a 1977 graduate from liberal arts, it's the way the world probably should be run. I've got questions for all of you, but I won't. Just first of all, thank you for including LGBTQI as a gay man. Thank you. And of course, we built, I think, our movement in this country based on the women's movement that allowed us to step up in the 70s. And so bringing these together might seem like it shouldn't be a fit, but it is. And so thank you. My question on the children incarceration, I kept hearing economic issues, that would be a cost saving. You said the children were 6 times more likely, if I'm not mistaken, to enter the judicial system, correct? Is this not a way to sell this concept to a broader base of legislators based on a tax-saving issue? It might sound crass, but if that's what it takes to get done, is that a way to do it?
You're absolutely right. It should be a bipartisan issue, alternatives to incarceration, because not only are we saving money by not incarcerating the adult parent, but we're also potentially keeping the children out of foster care, which is an expense, and then all of the ongoing associated costs with maybe breaking that cycle of risk of the child entering the system and incarcerating the costs associated with that incarceration, mental and physical health conditions create costs for the state, or can, and then there are ripple effects in schools too, in communities where kids are who have incarcerated parents because of the trauma can be acting out and not getting help, and that can also affect their classmates and their communities and others. So there's absolutely a good argument to be made that this not only saves money for the state, but it also is it's a public safety issue too.
I see a hand at the back, right up here beside Abby. And then maybe if you don't mind introducing yourself too, because I know there's a lot of alums in the room and people would like to know if you're an alum or just an interested visitor.
Sure. My name's Sandy Roth. I'm a graduate of law school, class of 2008. And I guess, this is kind of all new to me. I'm just generally interested in these types of topics. So when we're talking about prison nurseries, what exactly are we talking about? Are we talking about a separate area? Are we talking about, are the children with their parents or with their mother generally all the time? Is there an age limit? Is this kind of what you're studying? So that's, I guess, kind of my first question is, what are the prison nurseries? What do they look like? And if they vary, that's part of my question too. And then, I know there's been a lot of research on the effect of more research is being done on the effect of having parents in incarceration and the effect of that on children. But if with these prison nurseries, is there also studies analyzing the effect on the children of being in these prison nurseries? Because it seems like that could also have a detrimental impact on those children as well. So I'm just curious if that's also part of the research.
Yeah, that's a good question. So they're referred to as prison nurseries, and in some cases there truly are nurseries and daycares. In other cases, and then actually in some countries, New Zealand, for example, there are cottages where they're residences where these pairs can live. Other countries, there are no special facilities. The children are living with the mother and in fact have to share the mother's food. So there's no additional food provided, no minimal access to education, fresh air, or medical care. So it really varies. And in terms of whether it's for the benefit of the child or to their detriment, it really depends. We don't take a position on this because it depends on the alternatives, truly. A prison is never going to be an ideal setting to raise a child, but we would never call for the abolition of prison nurseries. I mean, ultimately, we'd like to see abolition, and everyone being able to stay out of prisons, in a perfect world. But in the short term, looking at the alternatives, a prison nursery might not be good, but if the alternative is a child being on the street or placed in a terrible orphanage in a country with few resources, then it could be the better of the alternatives. And what Alexa is working on is is developing a standard and evaluating in the individual case the alternative versus the prison nursery, and looking at the child's best interest in a case-by-case basis.
I see, yeah, right there, it's yours.
Great, thank you. Class of 1992. I was curious with the very first presentation, if when you were speaking about the educational things that were being done in the beginning in Bolivia, it sounded like when you came back around again with the young woman who was the case example, that she was the one who had attended these prevention courses. And I'm like, well, and then she became a victim. So is the focus of the classes, should it be a different segment of the population?
I'll take that question. Thank you so much for that question. So the original training that I was able to observe was put on by a large international non-governmental organization, and broadly, the training was focused on young people's sexual and reproductive health rights, and so letting them know you have a right to live, free of violence, you have a right to sexual and reproductive health care, you have a right to, education about your sexual and reproductive health. However, what we were hoping to illustrate through that case is that even though these educational initiatives are wonderful to teach young people about their rights, that human rights education is so important, if the context where they're living, there is no health care, there is no legal resources, if they are a victim, there's nowhere to go, kind of what's the point, I guess, of the education? Not to say that they shouldn't have it, but if that's not paired with actual material resources for the young people, it's kind of just lip service. And I come at this work, I'm over at the College of Education in the School of Public Health, and for me, I think in public health folks love education interventions because they're relatively cheap, they're relatively easy, and they're not super political, right? People tend to be like, oh yeah, we can teach about these certain health prevention activities. And so I think your point of what should these education interventions be about? I think number one, they should absolutely include boys and not just limit themselves to girls, and that's really common, I think, in a lot of global health, international development, education interventions. And then number two, I think to actually have more impact, it needs to be paired with ensuring that there is timely trauma-informed medical care accessible to victims, that there's legal resources that are available, and that the actual material needs of young people are taken into account. And it's not just these educational workshops that are 2 hours on a random day once a year. So that's what I was able to observe, and that's what I went back in last year to do some follow-up studying about.
I think we have another question. And if there are any more questions, because we might take a couple in a row because we have 5 minutes, and then we're going to have a recognition ceremony before we finish out. So are there any other hands here? Anyone want to ask a question before we? All right, why don't we go ahead and then, yeah.
Hi, I'm a 2021 alum, and I had a question about the Nepal study. I know you mentioned it's a two-part. One is what was the reasoning for denying citizenship to those children whose fathers have not a Nepali father, but married to a Nepali mother? And then I know you mentioned that there are some reforms coming and were introduced in 2023. From your perspective and what you've analyzed, how viable and how realistic are they to come through? And is this actually going to bring any change, or is this more of a talk of doing something?
Thanks very much, and I'll just say a couple of words and then hand over to the research team. It's a really good question, and I think part of the benefit that we've had with the project is the students have actually had an opportunity to speak with UN Women in Nepal. So UN Women's country office that is working on these issues and working on some of these reforms. So I think maybe, Caton, you might want to speak to the first question around the Citizenship Act in particular. But on the reform issue, this is a live issue as of 2023, and I think along with UN Women in Nepal, the part of the gap that's being filled by the research is sorting out where some of the advocacy points can be sort of teased out and serve as an example to other member states, but also bring some of these issues to the fore for the Nepali government. there are, I think, a range of civil society organizations that the teams benefited from learning about where they see sort of opportunities with those reforms. I think there, from my perspective and what I've gleaned from the research and from UN Women, there are still major challenges, particularly because the issue of amnesties is so central and intractable in terms of the gaps in the transitional justice mechanisms. But maybe Kate, and over to you, and then the rest of the team might want to answer. Thanks.
Yeah, so that's a really good question, and I think it has a lot to do with some of the root causes of the conflict in the first place. Through our research and through talking with our colleagues at UN Women and UN Women Nepal, it's quite clear that like one of the biggest issues in Nepal before the conflict, during the conflict, and now is the entrenchment of patriarchal and caste systems. And so a lot of the laws that have been reformed maybe haven't been reformed all the way. In particular, so back under monarchist rule, there was a law in place called Maluki Alain. Pardon my pronunciation on that one. And basically it forbade widows to inherit property from their husbands. And the idea being that widows were considered less than people, basically. Once your husband died, that's your entire worth. Once they're gone, you don't have a lot of worth left. And similarly, there's a lot of divides that exist in Nepali society based on caste and also based on religion. And so these things kind of informed the way that these laws were formulated in the first place. And despite all of these reforms and advocacy, they sort of still have a really heavy pull on Nepali society and Nepali law. And so in particular, looking at the Citizenship Act, that's sort of a vestige of this system that's been formally dismantled but still exists within the law.
And just to add to that, there is one of the primary aims of transitional justice is to avoid a recurrence of violence, and one of the areas in which there has been sort of the most tension and the closest that the Nepali society has come to a recurrence of violence has been on sort of the Indo-Nepal border, in part due to the Citizenship Act, because you have individuals who have children with Indian individuals who then would not qualify for Nepali citizenship under the Citizenship Act. So that's the closest that Nepal has come to a recurrence of violence. In regard to the reforms, as demonstrated by the 7-year process to get the TRC Act passed in the first place, it is a pretty prolonged process to get any sort of reform passed. So the fact that the reform bills have even been tabled in the parliament is pretty positive. And the fact that the 2022 November elections sort of led to this reopening of space has been seen as a very positive option right now.
Yeah, and thanks. Just to add to that, I think, it's important to note that there's a lot of dissatisfaction with the reforms that have been proposed on behalf of civil society, and I think that's in part due to just the large amount of impunity that still exists, the inaction on behalf of, police departments, local government, in addition to the national government, unwillingness to take action. And that comes from what Caton was speaking about in terms of just these entrenched patriarchal structures and viewing women as less than men in society, and the harms that have been done to women as a result of and after even those harms that are not related to the conflict are still failing to be addressed. So I think that's an important note as well.
Well, thanks. I am going to invite, if the panel is okay to stay there, we have a couple more minutes of programming. I'm going to invite the Executive Director of the Human Rights Center, Amanda Lyons, also an alum, to come. And we have a small award ceremony which Amanda is going to introduce, where we honor some of our graduating students.
So, hello everyone. Before we invite you to join us upstairs for a reception and hopefully we can continue the conversation, we just wanted to take a minute to recognize our graduating 3Ls and some of our visitors with the center. So it's that time of year, the students are getting ready for finals, and for those of us that have been working with students, we get to think about the students that we saw come into our offices as 1L and ask about how to do human rights work, and now we're watching them get ready to graduate. And I'm going to introduce the 4 students that out of a competitive process were selected for the Human Rights Center Outstanding Contribution Award this year, and I'm going to speak about them as a group, even though they've all worked individually and made really big contributions, but all 4 of the students have served as research assistants on several different projects. They've supported classes. They're really active in different student groups and kind of being leaders. I don't know how they're studying because I see them in there are parts of groups I didn't even know existed. And really importantly for the center, they have been ambassadors for the center, for the law school, for the university, with other departments on campus and with external partners here in Minnesota and abroad. And that means a lot to us as a community here at the law school to have such really well-qualified and committed and talented ambassadors. So we're very grateful for everything they've contributed the 3 years that they've been here with us, and we'd like to wish them well. So I'm going to ask them to come up individually. Suzanne Mead, if you'll come up, if you'll join me in celebrating Suzanne. And Elena McComber. And Sierra Paulson, please. And lastly, is Nicole here? Oh, Nicole Carter, please. I know, coming right from work. So, and I know we have other 3Ls. We have a great class of students, but it was important for us to get to celebrate these award winners with our alumni community. I think I'll hand it back over to Fanula for a couple more.
Yes. So, yeah, it's a very bittersweet time of year because, of course, our hallways are filled, the Human Rights Center is full, and part of what makes our Human Rights Center such a extraordinarily vibrant and intellectually stimulating but supportive places that we have visitors at the center. And we've had 2 exceptional visitors at the Human Rights Center this year, and Amanda and I both want to take the opportunity to recognize them here today. The first of those, I want to invite Tadele Akilom to come down. Tadele has joined us last year, April 2023. He's an extraordinarily well-known Ethiopian human rights lawyer who's been documenting and challenging human rights issues and the tragedy of the violations that have taken place in the Tigray conflict. And he recently submitted to the UPR of Ethiopia an enormously important submission that documents the work that he's been doing here. So we've been super grateful to have Tadele with us, and just want to acknowledge his time with us. Thank you, Tadele. And the second colleague I want to invite to join us is Professor Catherine O'Rourke. Catherine is one of the world's leading scholars in international law. In particular, her work on feminist legal theory and her work on armed conflict has sort of set extraordinary, broken intellectual boundaries, but also just shaped the discipline that she's working in. And it's been a huge privilege for us to have Catherine at the center this year. She has deep Minnesota roots because she's married to a Minnesotan, so she's not hopefully going away. We'll be seeing her again. But this year she gave enormous commitment and support to the center. She supervised students, she guest lectured, she's been presenting her work to us on centering care in international law. And so we'd like to invite Catherine to come down, Professor of Law from Durham Law School, and thank her for her year with us at the Human Rights. So I also just want to take a minute to thank some folks. I want to start by thanking our Executive Director, Amanda Lyons. Amanda keeps everything that happens at the Human Rights Center. I just want to acknowledge her many contributions in the law school, but particularly just to making the center such a vibrant and happy place. I also wanted to thank Abigail Nelson, who Anybody in the law school who knows how the Human Rights Center works knows that Abby is at the center of everything that works. And we have two undergraduate students, Freya and Grace, who are also, I hope, who are here, who may be here, who also have been really involved in the work that we've done. So thank you all for joining us. We hope that for those of you who are regularly in touch with the Human Rights Center, it's been fun to see what we've been doing this year. For those of you who are returning for your celebrations as alums, please be in touch with us. If human rights is something you were passionate about at the law school when you were a student, we are passionate to stay in touch with our alums. And for those of you who've come back, you're at a certain point in your career where you're thinking about new horizons and different things, and human rights is one of the things you want to be interested and passionate about again, please stay in touch with us. There's so many exciting things happening in the center, but also just our extraordinary students. And so thank you all for coming and join us upstairs for a reception. Thank you.